rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
You may be seated.
Yeah, you may be seated. That's unfortunate. It's a little hard to get moving, right?
You guys still understand.
I was gonna say, when I got hired in '97, my class was the tail end of 250 people got hired
Yeah.
from '94 to '97.
I started in the prosecutor's office in '95, and all those
3522 and 2023-10-3527. We are here for sentencing this afternoon. He is here with his attorney, John Grevin, on behalf of the state, prosecutors Jamila Mitchell and Emily Williams, and I believe the victim is here. So, Prosecutor Mitchell, how did you want to proceed?
Thank you, Your Honor. Your Honor, the victim, Chloe Jones, is present with her mother. We also have our victim advocate, Rachel Kane, present. It's my understanding that at this time, the victim would like a statement read by Rachel Kane for the court. At this time, we would wait until Rachel Kane does speak on the victim's behalf. Then the state would like to be heard. There's also several pieces of evidence that would have been presented at trial that we think is pertinent and should be shown for the court. Prosecutor Emily Williams will then play those few short snippets of videos of the defendant during this time of captivity for the court.
All right. Rachel?
Good afternoon, Your Honor. This is on behalf of Chloe Jones, the victim in this case. My name is Chloe Jones. A year ago, I was homeless and I came to you because you promised me shelter and safety. But that isn't what happened. You held me captive for 4 days, beat me within an inch of my life, strangled me, poured gasoline on me, and told me that you would burn me alive. Continually threatened to kill me. You made sure that I knew my life was fully in your hands and that you had complete control over me. You strangled me over and over again and told me, don't pass out. If you pass out, I'll cut your throat. All that time, all I could think about was my son and that I would never see him again. In fact, you promised me that I would never see him again and that I would never make it out of this alive. You held me under the constant threat of death by holding a knife to my throat. What happened to me over the course of those 4 days has changed me forever, not only mentally, but physically. Because of you, I have a traumatic brain injury that I will forever suffer the effects of. Because of you, I battle anxiety and PTSD, night terrors. Even in my sleep, I get no rest. It is an effort just to go outside, constantly fearing that this will happen to me again. But know that I will continue to live my life. You no longer have power over me, and I am the one in control. After this day, you will go to prison, and I will go back to my son, my family, and those who love me. I will continue to grow and live and heal despite what you've done. Your Honor, he has done these horrendous things before, and he will do it again. I don't ever want him to have the opportunity to hurt another person. He needs to go to prison for as long as possible. 25 years is not enough. He will still be a strong man in 25 years and still capable of hurting another. No time will ever be enough, but Your Honor, I have faith that you will hear my story and the state's argument and make the right decision. Thank you.
Thank you.
Your Honor, at this time, I believe Chloe's mom is going to take the statement.
Okay. Okay, so we're going to need you to state your, first of all, make sure that that light is blue there.
No worries. Hi, my
There you
name is
go.
Jessie Barham. I'm Chloe Jones's mom.
All right, could you spell your last name?
Barham.
All right, and then I know when doing something like this, anxiety and all that can get in there, so just try to keep it a little slower and tell
Yes,
me what
ma'am.
it is you want to share. Thank you.
Yes, ma'am. Thank you so much again. I did not prepare a statement because of the fact that I did not expect things to go this way today. The fact of the matter is that this man should not have even been out. He should not have even been free
because this is not the first time that you have abducted a woman, held her captive, and tortured her for days on end. This is not the second time that you've abducted a woman, held her captive, and tortured her. This is not the third time that you have abducted a woman, held her captive, and tortured her. This is actually the fourth time that you will be convicted of abducting a woman, holding her captive, and torturing her. You should never have been out on the streets in the first place in order to harm my daughter. And I pray to God, under these circumstances, that, Your Honor, you hear my daughter's story and know his story. Because it's not it's not if he will offend again, it's when he will offend again. And when in 25 years, he will be still a strong man, and probably stronger because they lift weights on those in those freaking jailhouses. And he will be a danger to society. He waited 2 months after his second conviction and serving 18 months in prison. He waited 2 months before he offended again. 2 months before he kidnapped another woman and tortured her. My daughter should never have been your victim. You poured gasoline on my child and threatened to burn her alive. You beat her over the head with a baseball bat. You beat her from head to toe for days. You punched her in her face so many times over the course of 4 days that she has paralysis on her left side of her face. She couldn't even open her eyes. She had blood dripping out of her ears. She had a brain bleed and was in ICU for 3 days. You did this to my daughter. You did this to my child. And you're not a man. That's not what a man does. A man protects women. You are evil. You're a villain. And you should never be allowed to see the light of day ever again, because you are a predator. You have an MO, and you've proven it time and time and time and time again. This will be your fourth conviction for the exact same offense. Oh, I'll say it again. Fourth time. Fourth time. Your Honor, my daughter is never going to be the same. She can't retain any new information because of she has a traumatic brain injury. She cannot even retain new information. She as far as working, she's not able to get a job, not only because of the physical, but because of the psychological damage that has been done to my child. She's going to suffer probably way longer than him, which is not fair. This wasn't a domestic violence sort of thing. This was not a back and forth. This was my daughter 100% of the time absolutely victimized and submissive to him, terrified for her life, as he promised that she was never going to get out of there. He promised her that she was going to die at his hands. He should be getting attempted murder charges with as many times as he strangled her and dared her to pass out because he was going to cut her throat if she did. He broke her arm and her finger just because she was trying to defend herself from a baseball bat to her head. Facial fractures. Yeah, you did. We got the medical records. Your Honor, all I ask is that you do what all the other courts and all the other judges before you did not do. Protect every single woman that he could get his hands on eventually. Your Honor, you have the power and you are within the law to put him away until he is no longer a danger to anyone, until he is feeble, until he is wetting his diapers. You don't scare me, William.
Ma'am, just stay focused on talking to me, okay?
Yes, ma'am. I apologize. The other judges before you barely gave him a slap on the wrist, and even 25 years at this point, in my opinion, would be a slap on the wrist, considering the fact that he has proven that he loves to do this. He has over 400 videotapes of my daughter being abused by him. He videotaped it because he's that sick. I don't know if he was going to sell her or sell the videos for some smut stuff online. I don't know, but I do know that anyone who takes 400 plus videos of my child getting assaulted violently, and threatened, her life threatened hundreds of times, strangled a dozen times at least. Anyone who has that in them to want to videotape that, there's something deeply, deeply wrong with that person. And that's the kind of person that has proven he cannot be allowed out in polite society, because that's just guaranteeing that someone else is going to have to go through what my daughter and countless, there's no telling how many girls he's done this to. My daughter just was strong enough to come today and be willing to testify, and that's the only reason why he pled guilty today, because he didn't want her to get on the stand and testify against him, because he knew that that would be damning. And I mean that. I'm not cursing.
Thank you.
That's all I have to say.
All right, thank you.
Thank you.
Prosecutor Mitchell?
Thank you, Your Honor. Your Honor, the state's going to put on the screen a photo of Chloe Jones on the day that she was rescued, and the police responded in Akron to that garage. Your Honor, on October 12th of 2023, Chloe Rain Jones thought she was meeting up with the defendant for something brief, maybe a night. Your Honor, that changed very abruptly. What initially was an encounter with William Mozingo, conversation in this garage owned by Mr. Mozingo's friends, Christine and Michael Scott, soon turned into a very aggressive speech and conversation. Chloe Jones was subjected to paranoia by the defendant and continual threats. Most importantly, her liberty was restricted by Mr. Mozingo very early on during her times in that garage. Your Honor, he started off agitated, and the state can say that with confidence because we do have those videos that were found and extracted from the defendant's phone. He took selfies and videos of himself as he berated Chloe Jones, as he threatened her, and eventually he restricted her from moving. After demanding that she not move and controlling her every step, the defendant assaulted Chloe Jones over the course of 4 days. What you're looking at, Your Honor, on the screen is Chloe as she had just emerged. Your Honor, we have temporary disfigurement as part of the Ohio Revised Code for serious physical injury. And Your Honor, the state submits to you, this is a prime example of someone who has suffered temporary disfigurement. She has one eye that is completely shut. The EMTs that dealt with her that day on the scene notated that she had pus in that eye. The other eye is almost nearly shut. As you can see, so much blood had accumulated in both of those eyes. There are videos on the defendant's phone that were extracted where he talks about her eye and then threatens to beat her in the other eye. Your Honor, as you can see, that's 2 separate beatings right there. Now, Chloe was seen at the hospital. She was admitted. She had a fractured nasal bone. She had a fractured bone in her hand. She had traumatic cephalohematoma. She had a traumatic brain injury, subdural hematoma, multiple contusions across her legs, her arms, her chest. She was swollen from the top of her head all the way down. If you look closely, Chloe appears to have a golden glow to her face. Your Honor, those are bruises to the entirety of both sides of her face and her cheeks. She suffered facial paralysis. She had bruising to both sides of her face near her ear, and her ear had blood in them. Your Honor, she was beat within an inch of her life. As Chloe's mom has stated, the defendant has been previously convicted of abduction in Adams County and Stark County. He was also most recently charged with kidnapping in Stark County in 2020, and he pled to aggravated assault, a felony of the 4th degree. We also think it's important to note that the defendant had escaped from CBCF. Prior to holding Chloe Jones captive, he was out on a warrant. We'd like to take just a second to thank the men and women of Akron Police Department for their efforts, for responding to the scene, providing Chloe Jones the help that she needed, for being aggressive in how they approached this case, for extracting all of the videos from the defendant's cell phone. Your Honor, I think it goes without saying that this particular defendant is a danger to our community. The state argues he's a menace. He's a danger to not only our community, but every community in Ohio. Wherever he goes, he will wreak havoc. His criminal history tells us that. The state is asking for a minimum of 25 years in prison. He needs to register and continue to register as a violent offender due to his convictions for kidnapping and abduction. And Your Honor, at this time, Emily Williams with our office is going to just give you a summary of some of those videos that we were discussing.
Yes, Your Honor, as Prosecutor Mitchell explained, these are videos that we extracted from the defendant's phone from an app called Alfred Camera, which we believe were being uploaded to his phone. These videos span from October 12th, 2023 through October 14th, 2023, so not the entire time that Chloe was in that garage, but the majority. I will also wanted to note that although we do have these videos, they are not the entirety of the day. So what we are going to show you are just snippets and a small segment of what Chloe had to deal with.
You don't have to stop. You're not allowed smoking, bro. You're not allowed smoking, bro. You don't have to stop. You're not allowed smoking, bro. You're not allowed smoking, bro. You light a fucking cigarette, I'm gonna beat your other eye shut. You don't get nothing. What'd you say? You don't deserve a cigarette, bro. Did you fucking pay me yet? Then you don't get no cigarette, bro. You don't get shit. From this fucking point on, you work for me, motherfucker, bro.
How much do I have to pay for a cigarette every time? Like how much, like, pack or... How much is a pack?
You're not smoking, bro.
I thought you said I have to give you money for a cigarette.
You know how I knew you were doing bullshit? Because you moved my phone.
And Your Honor, I think it's important to note on that specific video, defendant states, "I'm going to beat your other eye shut." As Prosecutor Mitchell indicated, our belief is that the injuries occurred on different days.
Where's my goddamn knife? Hey, listen, I'm gonna cut your fucking head off if you don't get my goddamn knife. I want to know where it's at now. Listen, if that board falls, I'm breaking your neck. You better stop moving. I want to know where my fucking knife is. I don't know. Listen to me. Listen to me before you open your stupid fucking mouth again. I don't want to check. I don't want a fucking maybe. I want to know directly where my knife's at. This X spot. Quit saying look. Tell me where it's at right now. How'd I get there? Huh? Fucking beat me again, you stupid bitch. I'm gonna cut this time. I'm gonna keep fucking holes in you and beat you to death, nigga. Don't lie to me again.
Your Honor, I will warn you, the next video is rather loud, and you can hear some cries from Chloe at this point. And Your Honor, just for context, the state believes that that is between the second and the third video is when they had fallen through the rafters. We believe that is part of when the defendant was strangling Chloe.
Okay. The more you stall, guess I'm getting. I don't like this shit, bitch. That's gas. What? I'm going to burn you alive, you whore. If you don't give me my fucking knife, I'm not going to shoot for it again. You too? You want to do that? I want to know right now. Right now. What? I said, don't let me ask you nothing more than twice. Now, what the fuck did you say? Tell me the nice little pillowcase. I said, which one? You lied. Huh? Now you mistreat me. So now it's my turn to mistreat you, right? Scoot down. Come on. Scoot down. I'm gonna light you on fire. You can turn to be honest. I had to ask you 10 times. I'm not good. That means where's it at? Okay. Don't answer. Don't fucking answer. What are you guys showing me, motherfuckers?
I said the black flag and my clothes.
That's not what you said.
My flag bag was put this was not the front one, it's the flag bag.
That's not what you told me. That's not what you told me, bro. You told me, you motherfucker, you said the pillowcase, you said the coat.
Yeah, it was so real. The thing was so flag bag.
Guess what? I'm about to dog you for that. I'm about to dog you.
I was just saying, it's the flag bag, it's the brown one.
You fucking lied to me again. Guess what? Guess what? I got everything here to cut your stupid ass up. Put you in that box. Just sit in that box, stand up. And all this duct tape and shit. Guess what? Put it back. You know how long it's been there? 30 years. 30 years. You'll be in here a fucking mummy, bitch. And I'll be out fucking killing other people and making a living life. Since you won't fucking lie to me. Shut your whore ass mouth. You just don't listen to the fucking words behind your dumb ass mouth. You're fucking stupid. Get your fucking head on there now. Get your head on there now or I'm gonna shove it down there. Get your fucking head on the goddamn floor. Right now. Right here. Right now. Right now. I'm gonna start cracking you. Listen, I'm gonna kill you with this. Put your fucking head in the floor right now. Not on my goddamn pillow. Right now. I said don't ever make me tell you more than once on anything. Push your... Don't fucking lie to me. You understand me? No, I'm like you're a kid. Understand that? You just killed that kid, bitch. I fucking told you again. Don't you lie to me. And what'd you say? What'd you say?
What time is it?
Three 30.
You really don't want Marvin's money?
What?
You really don't want Marvin's money?
Who's Marvin?
Like that?
You better think of somebody's money yet. This is probably the worst ass beat you ever got in life. Dude, listen, I can fucking tear you apart, nigga, and stomach it, nigga, and it don't matter to me, you hear me? I'll cut shit off you. I'll cut fingers off you and shit, bitch. I'll fucking stab holes in you. Until you bleed out, bro. I'll come up with the bread. You think I'm fucking playing with you? Not at all. Not at fucking all. Let me show you something. Let me show you something, motherfucker.
And lastly, Your Honor,
You want to talk about serial killers, nigga? You're sitting there telling one, you stupid bitch. You're sitting there talking to one, nigga. You're sitting there trying to tell me about serial killers and shit, bitch. How many fucking goddamn people I'm killing? You fucking retarded asshole, bitch. How many fucking people do this goddamn place? How many fucking times I've been in prison for this? Nigga, this is my dosing, nigga. This is what I do, nigga. You hear me? That's what I told you. Some people you don't fucking play games with, boy. You won't play games with, nigga. Don't you tell me my knives all over different places and shit? Have you running around looking and not finding it? Gotta come back and beg again? Okay. 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 I'm done begging, motherfucker. You're embarrassing me. I told you never embarrass me, bro. Oh, you want to embarrass me, fucking piece of shit, didn't I? Okay. Say what the fucking hell after that. You move a fucking thread. Fucking thread, bitch. And it's your ass, nigga. I'm telling you. That is no joke. And don't think I can't catch you. I'm very fucking fast.
and again, Your Honor, these are just a small segment of what Chloe had to deal with during that time of October 12th through the 16th. I do believe that it is important to hear not only how the defendant is treating Chloe, but how proud he is telling her that she's going to be a mummy and that he's just going to get 30 years. So I did want to emphasize that, Your Honor, on top of telling her, you know, to Google his name and that he's done this before.
So, Prosecutor Mitchell, there are 5 counts of felonious assault. Can you articulate for the court why you would be seeking, or which you would be seeking to be served consecutive versus concurrent? Because obviously we can't get to 25 years with the kidnapping alone.
Your Honor, oh, I'm sorry.
Before we get to that, would the court ask the state if they would agree, so we don't need to argue the kidnappings and the abduction?
Yes, as far as merger purposes. I
Yes,
think
Your Honor, we
spoke
do believe
earlier
they
about
merge.
that.
Yes,
So the 2 kidnapping charges and the abduction merge
yes,
for purposes of sentencing.
yes, Your Honor.
All right, but the felonious assault with 5 counts, if you could articulate what conduct is related to each one, so as the court would even be able to consider consecutive versus concurrent.
Absolutely, Your Honor. Your Honor, in count 3 is felonious assault based on serious physical harm. The state would argue that that is due to the broken nasal bone of Chloe Jones. Count 4 is felonious assault. That is also based on a deadly weapon being used. Chloe did articulate to Detective Hanlon of APD that she was hit with a bat. On count 5, Your Honor, count 6, felonious assault, that's based on serious physical harm. We would argue that that is going to be based on her traumatic brain injury, the TBI. Your Honor, in count 7, the felonious assault, we believe that is serious physical harm to both of her eyes. Arguably, she has 2 different incidents based on the videos, some of which you could hear a little bit that we played, that she was punched in her eyes separately. In one of those videos, I believe the defendant said, do you want me to shut your other eye? Your Honor, we believe that there is serious physical harm based on the part of the statute for the Ohio Revised Code for temporary disfigurement. That's why we showed the photo of Chloe when she was rescued. I think anytime you have that much disfigurement in your face and eye bone, not to mention all the collection of blood to the point where it's pus-filled and you cannot even see out of it, and you have such a long recovery, that in and of itself is serious physical injury. Your Honor, she also had then a fractured bone in her hand, and as we had stated earlier, Chloe was assaulted multiple times per day. She was also assaulted every day she was in captivity. Not to mention the bat that the defendant used on her was used all over her body. There are contusions that were noted by the same nurses, also by medical staff, and also photographed of bruising up and down both of her legs from the use of that bat. So she was not only hit on her legs, but she was also hit on her head as well. And this behavior continued over the course of 4 days.
By listening to the videos, it sounded as though activity might have occurred and then stopped and occurred and then stopped. Is it the state's position that these are distinct also because of the non-continuous nature of the actions?
Absolutely. And Your Honor, just to be clear, and I'm glad the court brought this up, we played those videos back to back. They all have different timestamps over the course of about an 8-hour time frame. However, as Emily Williams stated, that is just a snippet of what Chloe Jones went through. Okay, that's 8 hours out of 4 days. So the state does argue to the court that these injuries occurred over the course of 4 days. So there was a beating, and then there was multiple threats, and then there was another beating, and then there were multiple threats, then there was another beating. She was strangled multiple times at different times over the course of those 4 days. So these are different types of conduct over the course of 4 days, so different times as well.
All right.
Can we see those timestamps? My client has a different version. Are they on the actual videos?
Your Honor, all the timestamps are on the phone extraction that was given to counsel. And again, we only played, I think, 10 videos for you today. There are over, I believe, 400 videos on the phone extractions. They are all timestamped on the phone extraction.
All right, But it's not just the videos, but also her own statements to you that this happened throughout the time.
Absolutely, Your Honor. The defendant was indicted with each one of these counts, including the counts on the supplemental indictment, before Akron Police Department had a chance to actually go through that phone extraction. So these videos are things that were viewed over the course of months after this was already indicted. Those were indicted based on what Chloe Jones was able to recollect to Detective Hanlon shortly after the incident.
All right. Anything further from the state?
No, Your Honor.
All right, Attorney Grevin, your turn. Go ahead. You can use the podium if you want, yes?
Judge, first of all, we are not disputing he entered pleas of guilty to the kidnappings and the abduction, so we are not disputing that she was held against her will for a portion of this event. We are not disputing that she did suffer serious physical harm. What I will tell you a little bit differently, Judge, if you see the very first video that they showed where Mr. Mozingo was talking to her about payment, are you going to pay me for that cigarette? Are you going to pay me for that cigarette? The bottom line here, Judge, is Mr. Mozingo did not promise her that if she came with him, he would provide safety and security. He promised her that he would provide methamphetamine. So at least at the beginning of this, and if you look at the victim's statements throughout this and her statements to the hospital, this started out as a totally consensual, there was no issue because frankly, they're both getting high together. At some point in time, it goes south and things change. So when you watch those videos and when he calls her a bitch and when he calls her a whore and when he says he's going to cut her head off and all kinds of things like that, that still does not change, I don't think, the legal analysis that you have to do. So we've already, I believe, agreed that the two kidnappings and the abduction, they would merge for the purposes of sentencing. They talk about the felonious assaults being the various different injuries. She did have a broken fifth metacarpal on her left hand. She did have a broken nose. She did have a subdural hematoma. But to say that they happened at different times over the course of 4 days, or we would say 3 days, but regardless, I don't think that they can show that that happened. I mean, frankly, Judge, if these injuries happened when my client hit her with a baseball bat and that caused her broken nose and she's trying to defend herself and that causes the broken wrist and that causes a subdural hematoma, that's one animus. So if he slapped her on day 2, that's not a felonious assault. And if these injuries happened with the one beating with the baseball bat, that's one count of felonious assault. And I think the burden is on the state to prove that these injuries happened from separate times. Even if she was assaulted, misdemeanorly assaulted on these various different days, they have to prove that the various kinds of serious physical harm that she suffered resulted from separate animus, not at the same time. And I don't think they can show that, even if the court chooses to believe that this assault took place over a couple of days. I don't think legally that they've shown that. I think the most important video that they showed was, I think it was the third one where Emily said was going to be very loud. What happens in this situation, Judge, is they are living in a garage, and there are beams 10, 12 feet up in the air, and there's plywood on those beams, and that's where they would sleep. The video that you saw, video number 3, is at one point in time, and Chloe admits this to the cops, she admits it all over the medical records, that collapses, and she falls down without able to brace herself from 12 feet up in the air. So, do injuries come from that? Well, again, I think the burden is on the state to show that these are all separate animus. I don't know if black eyes are a separate serious physical harm. I do know that if you've ever broken your nose or seen anybody with a broken nose, the eyes are impacted the same way. Judge, he does have a record. We've discussed that. You know that. What I'm asking the court to consider is, on the kidnapping, because he has the priors, give him 11 to 16 and a half. On the felonious assault, you know, Chloe's mom said he pled guilty because he didn't want to hear her testify. In a way, that's true, but he pled guilty because he didn't want her to go through what would probably be the worst day, which is definitely the worst day of her life, frankly, on national television. I think he deserves credit for not letting her do that. I would ask you to give him 5 years on the felonious assault, and I do believe that they merge, and then 2 years on the escape. If you run those consecutive, that is 18 to 23 and a half. I think it's appropriate in this case. I think, you know, people that murder people, Judge, in the state of Ohio, get a chance to get out at 15 years. I think a sentence of 18 to 23 and a half is appropriate. I would ask you to merge those felonious assaults because I don't think the state has met their burden to show that there was a separate animus, and it is their burden. They have not done that. And again, 18 to 23 and a half, I think by that time he will be well into his 50s. That's what I'm going to ask the court to sentence him to.
What about the strangulation charge? Count 10.
He pled to it. I would ask you to run that concurrent because I think the strangulation kind of is part of the felonious assault. I mean, or that would be the one separate thing. It would be a different animus for the strangulation than it would be for the serious physical harm on the felonious assault. So frankly, if the court chose to run that consecutive, I think legally you'd be okay to do that. But I would ask you to fashion a sentence of whatever you see fit for 18 to 23 and a half. Thank you.
Thank you. Did your client wish to say anything? All right, let's make sure the mic is to it and. Go ahead.
Yes, ma'am. First, I would just like to apologize to the court for taking up everybody's time and resources for the situation I placed myself in and this court. Second, I would just like to say that this incident stems whenever we was both fueled up on methamphetamine, and I was already placed myself in a very bad situation. You know, as they said, I was already on the run for an escape, and so I've had a lot of time to think about it and reflect. And at this time, I'd just like to apologize to the victim and their family.
All right, thank you. Did the state want to respond to defense arguments that the felonious assault should merge for sentencing?
Thank you, Your Honor.
Be concurrent, I guess, is.
Yes, if I could. Your Honor, I think we've already stated all the reasons why the court can find that the felonious assaults do not merge. I think counsel talked about our burden, but ultimately it's up to the court based on everything you've heard at sentencing, as the defendant has already entered a plea of guilty to each one of those felonious assaults. So, Your Honor, if you find that the state has convinced you that these beatings resulted in different injuries that were serious over the course of those 4 days, then that is the separate animus needed. And I believe that finding will stand up on appeal. Your Honor, the state also forgot to ask for the violent offender registry based on a conviction for the kidnapping, and also asked that the escape run consecutive as by law.
Thank you. Attorney Grevin, anything further?
No, like I said, I don't think they can point to what caused what, and because of that, I think serious physical harm is serious physical harm. I mean, you know, Judge, if I shoot somebody 3 times, that is 3 times can be 3. I guess technically 3 times felonious assault, but it's 1 act. They would have to merge. They would have to be concurrent. If you do it on 3 separate days, and run those consecutive, but I don't think that they've shown, and it's their burden, that whatever caused these serious physical harm, that one happened on a Tuesday, and one happened on a Wednesday, and one happened on a Thursday, They are not able to do that. So if they can't do that, I think that these necessarily need to be concurrent. And that's all, although I would ask the court, could you just come up side row real fast?
Yeah, over here.
Yeah, because we have the court reporter.
All right, anything further?
No, Your Honor.
No, Judge.
Okay, well, this is a difficult case, there's no doubt. I think we're all glad it didn't go to trial, honestly. Certainly, the conduct here is extreme, and I believe it should be met with extreme punishment. I don't think there's any doubt about that. I'm never going to understand how one human can cause serious harm to another. I'm never going to be able to understand that. The pain and harm that you've caused for this victim is going to never be gone from her. She's got serious and long-lasting consequences from what happened here. And we may never know what was going on in your head or what caused you to do these things, but what I am going to do is follow the recommendations of the attorneys and impose a sentence, whereas you will not be out and able to make these types of decisions again for quite a while. I'm going to start by reviewing the violent offender form, which I'm going to give you to sign after I've reviewed it. So, you have been convicted of or pleaded guilty to a qualifying violent offender offense as defined in Ohio Revised Code 2903.41. If you're not you are sentenced, hold on. Since you're sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after your release from prison. If you are an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of residing in or occupying a dwelling in Ohio for more than 3 consecutive days, or to residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You are required to provide the sheriff certain information, including your full name and any alias you use, your residence address, your social security number, any driver's license number or commercial driver's license number or state identification card number issued to you, information regarding the offense of which you were convicted or pled guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle, and a description of each vehicle. A description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you are required to re-enroll annually. You must update and or amend any of the information described above that is changed, and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially enrolled. If you change your residence address during the 10-year enrollment period, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You are required to comply with all of the above requirements for a period of 10 years. Since your expected release residence address is in Summit County, you shall enroll in person no later than 10 days after release with that county sheriff's office at 205 East Crozier. Failure to enroll or failure to verify residence at the specified times will result in criminal prosecution. I'm going to have you sign this acknowledging that this has been explained to you, that you understand the requirements, and that you must abide by all of these provisions of the Ohio Revised Code. going to get you a copy of that before you leave today. So when I am making a decision as to sentencing, I have to review the seriousness and the recidivism factors set forth in the revised code 2929.12. Clearly, and when we look at the seriousness factors, the victim suffered serious physical, psychological harm. And when I look at the recidivism factors, at the time that this happened, you were under post-release control for an earlier offense. You had a history of criminal convictions. You were out on a warrant at the time, and despite prior attempts to rehabilitate you, you engaged in the same behavior that you'd previously engaged in. And so I will find that both the seriousness and the recidivism factors weigh in favor of a prison sentence in this case, which I think is no surprise to anyone. Based on all the facts and circumstances and consideration of those relevant sentencing factors, considering the statement of the victim and the victim's family, the state, the defense, your statement, applying the minimum sanction, I'm determining will protect the public and punish you without imposing any unnecessary burden on state and local resources. And again, analyzing all the factors I'm required to analyze, I am going to impose the following sentence. So on counts, I will find that counts 1, 2, and 5 do merge for sentencing purposes. And on those counts, on count 1, I will impose a sentence of 11 to 16 and a half years under the Reagan-Tokes law, and I will review that with you again in a minute. Because that is going to be the longest sentence that I impose, that will be the one that will carry the Reagan-Tokes tail. On counts 3, 4, 6, 7, and 8, all felonious assault counts, I am going to find that at least 2 of those are separate offenses. When I look at the TBI that was suffered and the injuries to her eyes, clearly there was enough of an impact to cause that type of injury. And then we've got the testimony of going to hurt your other eye. We've got the videos demonstrating that, and all those factors. I would consider any head injuries to be one serious physical harm, which would warrant a separate sentencing for purposes of everything. And then also we have the use of a bat, which is a deadly weapon, and then also we have the fractures in her hand and the bruises all over her body. I mean, I just don't see how bruises can be developed in different stages if they didn't happen in different stages, and that was what I was told today, is that the bruises were in different stages of development. So I'm going to impose a sentence of 5 years on count 3 and 5 years on count 4. On count 10, and counts, and I guess I should be more specific. On count 6, 7, and 8, I'm going to impose 4 years. I'm going to state that those 3 counts can be sentenced separately, but those will run concurrent with each other, but consecutive to counts 3 and 4, which will be consecutive. So we have 11 and a half, 16 and a half, plus another 10. The strangulation is a separate offense. I don't know how anybody could possibly, the legislature went to the bother of creating a strangulation offense because of the fact that we have this activity occurring in our society right now where people think it's okay to strangle somebody. For that offense, I'm going to impose 2 years, and I'm going to impose 2 years for the escape. So that comes out to 25 to 31 and a half years. I am going to run counts 1, 2, and 5. Obviously, we said that merges. Consecutive with counts 3, consecutive with counts 4, concurrent with 6, 7, and 8, and consecutive with 10. And then the escape on the other case is consecutive by law. I will find consecutive sentences are required by statute because, first of all, for the 2 count cases, because the escape must run consecutive, but also In the kidnapping case, I believe consecutive sentences are necessary to protect the public and to punish you, and they're not disproportionate to the seriousness of your conduct and to the danger that you pose to the public. And both of these offenses were committed while you were out on post-release control, and your history of criminal conduct demonstrates consecutive terms are necessary to protect the public. I will note, as you know, you're not allowed to use drugs or alcohol while you're in prison. You may be tested for that. We calculated your jail time credit on our break. There's 394 days of jail time credit will be added to your journal entry. That starts today, or ends today. So anything after today, ODRC will calculate for you. So if you go back and you want to check it, we calculate as of the end of today. I told you upon completion of your prison sentence and upon release from prison, for the felony 1, you will be supervised on post-release control for a mandatory minimum 2 years up to a maximum of 5 years as part of your sentence as determined by the parole board. There are, on the other charges, there are lesser lesser sentences for PRC, but because we have the highest level offense, that is the one that will be imposed by them. And I did tell you what would happen if you violated post-release control. Do I need to review again what would happen, or did you understand?
No, ma'am.
All right, I also need to, on the record, talk to you about the Reagan Tokes, the 11 to 16 and a half. As I indicated, we take the 11, we cut it in half, and we add it to the end, and that's how you get the tail. I reviewed with you earlier today that it is possible to earn good time credit of 5 to 15% against your sentence. Would you like me to review with you again how you do that, or are you satisfied with what you've been told today?
I'd like you to review with me.
Okay, so if ODRC recommends a reduction, it is presumed that you will be released at the presumed early release date. They would notify the court. If I don't agree, I would notify the state and the victim, and we would have a hearing. And at that hearing, I would have to find that the presumption was overcome in order to not agree to that. The factors I would look at to see if that presumption was overcome: did you violate rules that compromise prison security or safety of staff or inmates, cause harm to staff or inmates, or violate the law while you were in prison, and those infractions indicated that you had not been rehabilitated, or if your behavior while incarcerated demonstrated continued threat to society, or if you were still security level 3 or higher, or if you did not productively participate in a majority of rehabilitative programs that were recommended, or complete a reasonable number of programs that you started, or if you did not have a fixed residence address upon your release. Any of those reasons would cause me to pause, potentially find that the presumption for early release was overcome, and then you would serve your regular sentence, that was whatever the sentence was imposed. Alternatively, when we get to the 25 years, there's another 6.5 years there that ODRC could keep you if they chose, and they also have standard they need to follow. Once you get to the 25, I no longer have any control over that. At that point in time, they would be looking at, did you violate rules that compromise prison security or safety of staff or inmates, or cause physical harm to staff or inmates, or violate the law while you're in prison? Did that indicate you had not been rehabilitated and demonstrate that you continued to pose a threat to society? That would be one prong for them. So it is a higher standard for them. If you were in extended restricted housing anytime the year prior to your release, so that's, you got to kind of be in trouble to be in extended restricted housing. If anytime that year prior, they could say they're not going to release you. And then again, if you were still security level 3 or higher, those are reasons that they could say they weren't going to release you. They would set a new date for you to be reviewed, and then at that time they would go through that whole thing again. They could not hold you longer than the 30.5 years. Okay? All right, and then finally, you do have the right to appeal the conviction, or actually the sentence in this case. You do that by filing a notice of appeal with the clerk of courts of the Court of Common Pleas within 30 days of the sentence. If you're unable to pay the costs of the appeal, you have the right to appeal without payment of those costs. If you're unable to pay counsel for the appeal, the court will appoint counsel without cost. If you're unable to pay for the cost of documents, unnecessary for the appeal, those documents will be provided without cost. You have the right to a notice of appeal filed timely on your behalf. Would you like to appeal now, or would you like to talk to counsel first?
During the break, we had discussions down in the holding cell and everything. We talked about the merger issue, the floating assault and everything, and he has indicated that the court decided the way it has. He would like to have an appeal. I can tell you he's indigent, and I would ask the court to appoint someone to appeal this and get the ball rolling.
Alrighty, so we will appoint a lawyer to handle the appeal. That's a separate list, so I need to grab that. To do that, they will contact you in order to prepare for that. For whatever happens, I would just say that, you know, again, I don't understand how this type of thing happens in our world today, but it does, and you're going to be in ODRC for quite a while, and there's a lot of programming available to you there. I don't know that you've spent a lot of time up until now. I don't know how much programming you actually were given up until now, but I would urge you to use this time to improve yourself and strive to understand the things that are within you that are driving you to make these types of horrible decisions, because when you get out, you certainly, that's the last thing you want to do is go hurt someone else and end up back in prison for the rest of your life. So please use this time wisely, and Chloe, make sure that you take advantage of all the opportunities available to you to deal with, like you said in your letter, for you to deal with your stuff, okay? Because this could either be a life sentence for you too, or it can be something you learn and grow from and use to help others. And that's really on you, how you proceed with that. So I wish you the best and good luck with that. My staff reminded me fines and costs. I'm going to waive the fines and the court costs associated with this case. You are indigent, you're going to be incarcerated, so there's no reason to try to collect those from you.
I wanted to ask you, is there any way that I can get an emergency ride out to prison? I've already been sitting in this county jail, I think 15 months now.
So the way it works is we have to do the journal entry, and the jail has to have the journal entry before they can transfer you, but we will do our best to get that done quickly. We're not behind on our journal entries, so we should get it done probably by tomorrow. If the clerk processes it, it should be in there, and by the end of the day tomorrow, the sheriff, or the next day, the sheriff should have it, and then they schedule it from there, but I don't really have any control over that. But I can tell you that I'm sure that they would love to use your bed for someone else as well, so they do move people as soon as they can. All right. Anything further?
No, Your Honor.
No, Judge.
All right. Good luck to you, sir. Thank you.
Yeah, right.
Anything else?
Yeah.
Good luck to you, Ms. Chloe. I meant that. Yes. Take care
That's
of
what
you.
I thought.
The system's rigged, man, it's time to